Why do you think that the Attorney General hasn't looked onto that yet?
We've brought it to his attention. The only one that appears to be doing anything is Mr. Sampson over here, and Mr. Price, I guess, from Harlem, or Perkins from Harlem, and Mr. Patterson.
So you're saying the Attorney General knows about this?
He told me to stop writing him letters. That ain't gonna happen on my watch. Oh, yeah.
Well, Mr. Rose, if you can provide me some more information, I'm very interested in this returnable security deposit.
That's the source right there. We would like to invoke the whistleblower's law because we know that there's a good chance that hundreds of millions of dollars, if not billions of dollars.
Who's that you point?
That's Mrs. Catherine Wilson.
Ms. Catherine Wilson, why don't you just have that seat? I just want to ask you a couple questions about this returnable security deposit.
This woman is brilliant, and she's
very interested in. We're very interested in that. I'm quite sure we're very interested in that.
Thank you, Senators. Thank you for your time. My background is several things. I used to be an auditor, and I did not work for the Rockefeller family. I actually was a global auditor for Reader's Digest, conducting operational audits and reported directly to their board of directors, which included Lynn Cheney and David Rockefeller. I was also, as I refer to it now, married to the Bob for 20-something years. My ex-husband is a law secretary with the New York State Supreme Court, and when he divorced me, I then became a victim of the power plays within the system and essentially got, well, shagged, for want of a much better word. But in terms of the returnable security deposits, there's actually much more at stake here. And if I may, I'd like to take a moment to explain it. I actually had an entire presentation, was hoping I could be allotted 10 minutes, but I'll give you the Reader's Digest condensed version here.
Yeah, 5 minutes.
Fine. In both in divorce situations and particularly in surrogates court, we have essentially a license to steal. And it happens for two reasons. One, because surrogates court is the most political of all the political appointments in the system. I know this from being behind the scenes for 20 years. And as you know from Lopez Torres versus the state of New York, where the United States District Court referred to the New York State judicial appointment system as the most corrupt in the nation, the most corrupt of the corrupt are the surrogates courts, because they get to make the appointments to the attorneys, the accountants, and the guardians who will be overseeing the trusts and the estates. Now, this is critical for two reasons. The trusts are for vulnerable people. We're talking about the disabled, the mentally ill, people who have no one else to advocate for them. And for the estates, make perfect victims. They're dead. What happens is, in surrogates court, so many times, the money disappears long before the estate action takes place. So in the new law that the Senate passed, and I thank you for this, the power of attorney law does take some steps to address the issue. But the real issue is on the people who have control over the money while the individual is still alive. And that includes the agents with the power of attorney and the trustees. There is supposed to be an accounting that goes on to the courts for the trustees, but no one enforces that law. The surrogates court in Westchester County in particular is a joke. They do not have full accountings. Also, the accountings that were proposed by the administrative judge, Jonathan Littman, are not what any decent accountant would ever refer to as an accounting. They are essentially laundry lists of numbers. You start with the numbers of where you begin with the finances at hand, and you account for what you've spent in and out, and then you give the ending total. There is no documentation, no backs and fronts of checks, nothing that would support why this money was spent. Plus, there is nothing to say that the numbers you are starting with in the individual's estate or trust are the numbers that should have been there. It is improper accounting to start at the point in time that the money's handed over and comes to court and say, this is what we're starting with. I'm involved in a trust at the moment in an estate where the numbers we're looking at are less than $100,000. But the numbers that were there 3 years prior when the thief got his hands on the power of attorney was $1.7 million. Now, how the state is suffering in all of this is, in the question of the returnable security deposits, these are monies that should be going back to the individuals. If the security deposit was not fully spent in expenses in the nursing home, then the balance is due back to the family and to the state. I'm sure you would agree. So those are personal victims. But how the state is being affected is in the issues of the transfers of assets. For example, say Senator Adams, I appoint you power of attorney for my funds because I am now suffering from dementia, which, as you can understand, is a growing concern in the state as the population ages. I have $1 million that I've accumulated through hard work over the years. Senator Adams, you get your hands on my power of attorney. You now go to my accounts and you see I have $1 million. You suddenly realize that I have only 1 or 2 family members, equally elderly, who will never don't know what's happening in my funds, have no idea I've accumulated this money. So you, with power of attorney, start writing checks to yourself. By the time I die and my estate is now probated and my elderly siblings stand to inherit, there is only $10,000 left in the estate. How we can catch these individuals is they all make one mistake. Accountants like to say that all criminals have one thing in common: they cheat in their taxes. If you look at the estate tax returns and the individual annual returns filed by the powers of attorney for the individual whose finances they are in care of, whatever withdrawals they made from those funds in excess of $10,000 a year should be declared as taxable gifts. They're not, and that's how I can nail them every time. Those are taxes that are due to New York State and the Internal Revenue Service. So we were talking about state tax fraud and federal fraud. Excuse me?
Run that by me again.
I figured you'd be interested in this. This is a nice way to get tax revenues where nobody will mind because we're catching the criminals. You have power of attorney over my estate, $1 million. I've got dementia. It takes me a few years to die, but that's okay. You start writing yourself $25,000 checks out of my bank account during those 3 years. So by the time I die, there's nothing left in my estate for Senator Adams and Senator Diaz to inherit. But when you file the estate, my relatives show up, Rick, there's only $10,000. He tries to do a discovery. He goes, there's no full accounting, so there's even no way at present within the court system to find out how much has been stolen. Because if you go to the court and try to do a discovery, the court will only allow you to discover the documents that are on hand at the time of the estate. So that if you were smart enough with the power of attorney to transfer it to new accounts, I will never know. And if you ask in the discovery process for any and all documents that might have been out there, it is referred to in the court system as a fishing expedition, and it is denied. Accountants refer to that as due diligence and would never be denied. What we need to do is change some of the legislation. We need to put in place in the discovery process that we can pull credit reports of the individual, either the person for whom the trust is being established and the trustee, the person, the deceased, etc., at the time either the trust was established or the power of attorney was issued. So therefore we can tell at that point in time any and all bank accounts owned by that individual, all assets owned by that individual at that time. That then becomes the basis for the discovery. If we then find that during the period of time between the exercise of the power of attorney and the death of the deceased, that millions of dollars or even $10,000 has disappeared from the, well, actually it would have to be greater than $10,000, I stand corrected, but say even as minimum as $20,000 has been depleted, and the returns, tax returns in the discovery process do not show that the person who was the trustee or the power of attorney agent declared those withdrawals as taxable gift income, and they cannot prove the withdrawals were for the use of the trustee or the individual, now we have tax fraud. I have a case where the $1.7 million was withdrawn over a course of 2 years for an individual who was covered under a veteran's VA hospital insurance plus his own private medical insurance, and he was withdrawing an average of $33,000 a month for a father who was being housed in a VA facility. somehow I don't think that $33,000 a month was going to the dad's care. So that's $300,000 average annually per year that was being depleted from these funds that far exceeds the $12,000 allowed annually by the IRS for gift tax, for untaxable gifts. Therefore, that should have been declared on as a taxable gift on the tax filings. That's how we can catch these criminals. Thank you. I do have other issues, and I would appreciate some time later if possible.
I just need to get your phone number. And my lawyer will be contacting you. I think that. No, let me ask you another question. About roughly.
Yes.
How much money do you think that the state will save if we solve this problem?
Well, right now, if you did the backlog, I would guess off the top of my head, and the top of my head with my financial experience is usually pretty good, but I would imagine it runs in the hundreds of millions of dollars.
In a year?
Easily, because the estate I looked at was $1.7 million that was depleted. And only $10,000 a year is allowed, so if we're looking at almost $1.7 million at state taxable rates of 5%, that's a lot of money in just one estate.
The gentleman just said before that he had written to the Attorney General and that the Attorney General asked him not to bother him no more. That's what you said, right?
That's true.
No. Was that what you said?
Yeah, I got a letter from one of his people that told me to stop writing.
Stop writing.
Well, this is an explosive issue.
This is a public hearing here.
Yes,
And you are practically accusing the Attorney General of
I was told to stop writing them letters about this topic.
So you're saying that the Attorney General knows about this?
I don't know him specifically, but his underlings told me to stop writing the letters.
And you have the name of the person that wrote to you. Can I get a copy of that letter?
At this time, I don't know if I can produce. We're talking about a history of 10 years.
Yeah, but you're in a public hearing now.
I understand.
You are testifying that someone in the Attorney General's office wrote to you.
I would love it if he stepped in immediately.
No. This is
Well, I think, Rev, I'm sorry, Rev, go ahead. I apologize.
My concern is, it's a public hearing. You just said, before you testify, that someone in the Attorney General's office wrote to you.
No, they told me.
Or now they told you.
Yes, well, it's either in writing or they told me to stop sending them letters.
So there is no proof of that.
There may or may not be. At this point, you're asking me to dig up a piece of history that I don't know if I can put my fingers on.
Okay.
To the best of my recollection at this time. To the best of my recollection.
All right.
Okay.
Because-
On this issue of, I've only
because-
recently
let me-
contacted the state
we
attorney
just want
general's office.
We just want to be fair
Oh, I understand.
to everyone. Because this is a public hearing, and when you make a statement, the kind of statement you make, there are people listening, and people get. I got a wrong impression. You said, I said, what?
Yeah.
But now I'm clear. Now there's no proof of that.
Yeah. I would also like to indicate that a lot of this is abuse against elders.
I assure you that when I contact, my lawyer will contact the lady here, the Attorney General will know.
Definitely.
If he doesn't know.
That would be wonderful.
Just make sure we get your information, please.
I would like to
Hold on, Senator Adams. We're being joined by Senator Bill Perkins from Harlem. Senator Perkins.
I'm sorry, your name again, please? I'm sorry.
Oh, Catherine Wilson.
Oh, Catherine, can you just give me your background on,
Certainly. I mean, I could give you what I was going to present.
just a brief background, your financial, your accounting background, so.
Well, I used to be an international auditor for Fortune 100 companies, and then went into private consulting and worked for various small companies and even a couple of local government agencies. And I now work for small companies. I also do some writing for a local newspaper, and I actually left you 10 copies of my articles that are pertinent to these issues at hand. I also, for 20 years, was married to a member of the